Okay, Shannon, you can put us back on.
Okay.
Okay, go ahead, Ms. Burks.
Thank you, Your Honor. Sarah, I want to start with a comment that you made about abuse. And while I'm not sure that it's completely relevant, I want to touch on it. Is it true that the only documented abuse is from you to Bridget?
No.
Okay. You also mentioned that there's a grandfather's sleepover at the school. Where is that on the calendar? That's the exhibit number 1.
I don't have the exhibit listed in front of me.
Would you,
in June?
Yeah, would you please
want me to
pop
screen
it back?
share?
Would you do that, please?
Yep. Do you see it?
Yeah, we've got it. Thank you.
Okay.
That's listed as June 4th. The kids camp in, camp out. And then on May 27th, there was Grandparents' Day talent show. Last year for the school, for the camp in, camp out, that was in conjunction with the grandfathers taking the kids to school for dinner, bonfire, sleepover. And if that is the same for this year, then that is what they've planned on.
Okay, but you don't actually know if that's the same, correct?
It is my assumption it is.
Okay. So if Bridget had contact with the school and the school told her that Avery's not participating in that, you would have no reason to doubt that either. Is that right?
Well, so I guess it would depend. Unless she's got knowledge of the question that was asked of the school and hearing the school's reply, then I don't think we would have a foundation for the defendant to answer that question.
My question was, if Bridget contacted the school and the school told her that Avery does not need to attend that, her class is not attending, would there be a reason to doubt that?
Well, and again, I'm back to my same lack of foundation, but this question, this statement you just made was different than your last statement. This time you interjected the word need. Bridget does not, I'm sorry, Avery does not need to attend.
Okay, well, hold on. Before we spend any more time on this issue, my understanding is that the plaintiff called the school and asked whether the preschoolers participate in Grandparents' Day talent show on May 27th and was told, no, they do not. What I'm hearing defendants say is that the June 4th incident, which says kids camp in and out, was actually a grandfather sleepover, which is a different event from the Grandparents' Day. So it looks like we're talking about two different things. And if I've got that wrong, I am willing to be corrected.
My client says you've got it perfectly right.
Thank you, Your Honor. One minute. Sarah, from May 19 to if Avery is participating in this kids camp in out on June 4, she will not be attending school, correct?
I'm sorry, could you repeat that again? May of 19?
Will Avery attend actual, let me rephrase the question.
I'm sorry.
Will Avery attend school after May 19?
Not in the classroom setting.
Okay, thank you. For the Mother's Day request that you indicated that you made for the drive time, you indicated that you asked Bridget to return Avery to Whitehall. Is that correct?
Yes.
Okay. And then the initial exchange would still be at Coopersville. Is that correct?
Correct.
Okay. And Bridget asked you if you would be willing to do the drive to her, and then she would do the drive back to you. Is that correct?
Yes,
Okay. And isn't it true that you didn't want to do that because you would be late for church?
yes. Arriving in Coopersville at 9 a.m. does not provide me sufficient time. Arriving in Coopersville at 9 a.m. provides me sufficient time to get back to church in New Era by 9:30 when it starts, a couple minutes late. If I was to have to meet Bridget in Rockford or Canadian Lakes, where either location where her requested pickup locations, I would be unable to attend church on Sunday morning.
And Avery wasn't attending church with you, correct?
Correct. Avery would be with Bridget at that time.
Okay. You indicated that Jackie from the front of the court told you that the default day for midweek parenting time is Wednesday.
Yes,
That's not in the front of the court handbook, right?
that was when I was counseled by Jackie in a phone call.
Okay. Do you agree that the front of the court could modify their policy and make it Wednesday if they wanted to?
Well, there's no foundation for her knowing what the FOC can do.
I agree. She has nothing other than speculation, which isn't helpful.
Sarah, in 2019, there was a parenting time complaint when you withheld Avery for over 4 days because you didn't feel that Bridget was entitled to a Christmas break. Is this correct?
I'm sorry. She's asking about the parenting time hearing that we had.
Was there a parenting time complaint in 2019 because you withheld Avery from Bridget over Christmas?
There was a parenting time complaint hearing that we had, yes.
Okay. And you had called Jackie and she told you that Bridget was entitled to parenting time. Is that correct?
There was confusion.
Okay. So, but when Jackie told you that there is parenting time over Christmas, you said there was confusion, but when she tells you that it's a midweek on Wednesday, that's not confusion. Is that right?
She was very clear on her midday conversation that we had.
Do you know how many parenting time complaints have been filed against you?
I believe 6
Okay.
Individual.
And do you know how many of those were valid?
1.
So makeup time was
But-
only awarded once?
Correct.
Okay. You indicated that you adjust your hours annually to accommodate Avery's schedule. So when she went to school Monday, Wednesday, Friday, why were you working Tuesday, Wednesday, Thursday?
It is my goal to be with Avery as much as possible on the days that she goes to school. That way that I can drive her to school. If there is any activity at the school during her school day, I could participate, whether it be volunteering in the classroom, with chapel, anything like that. Also able to drive her home at the end of her school day to be able to talk about what happened at school and to go over the day's events with her. So by picking the Tuesday, Wednesday, Thursday work schedule, it maximized my involvement in Avery's school, because it would then leave only Wednesday, which is by the FOC's designation, the midweek parenting day, if we can't agree, knowing that Avery would be with Bridget on Wednesdays. I was maximizing my ability to participate in her schooling.
Isn't it true that Bridget asked you to modify to a Tuesday before this motion was filed regarding the hearing today?
Bridget has made multiple proposals to me. Yes, that was one of them.
And you had denied that until recently, correct?
Yes,
Okay. Even though you were working on Tuesdays, you didn't want Bridget to have Avery on Tuesdays.
that's not a correct description.
Okay. So explain why you didn't want Avery to be with Bridget on Tuesdays?
It's not that I don't want her to be with Bridget on Tuesdays. Bridget is allocated midweek parenting time as part of our divorce or the parenting time order. It's not, they're not wanting to. It's that the proposals are constantly changing. We are unable to agree on what we think is best for Avery. I have expressed that I think it would be best if the time for Bridget's midweek visit was added on to her weekend time of that week. Bridget disagrees. We're unable to agree on it. I have accepted multiple proposals from Bridget. Each time I accept the proposal, the goalposts change. It's simple as that. I've accepted the Friday one and the goalpost changed to alternating weeks. Accepted the alternating weeks, the goalpost changed to adding weekend or adding the summer parenting time. And no matter what I agree to, it doesn't last because they just, Bridget adds more onto the proposal.
Do you agree that it's important for Avery to have contact with her parents more often than every 7 days?
No,
So if you went 7 days regularly without seeing Avery, that would be enough?
that would be speculating. I'm unsure of what it would be like.
Well, you just testified that it would be okay to go 7 days. I'm asking if you would be okay going 7 days. That's not speculation. I'm talking about you.
I don't know because the situation isn't in front of us. It's being that I'm the primary parent. It's not a position that I'm in to have to go 7 days without her. Now, over the summer parenting weeks that we do have, we have multiple times where Bridget has chosen summer parenting weeks, one of which Avery has gone from me for 2 weeks. She comes home at 6 o'clock one evening on Thursday evening, and the very next day she is scheduled to go back to Bridget's house for a parenting time weekend. That is 17 of 18 days gone on my end. But because it's what the order says, that's what we're doing until we have something different as far as right now goes.
So wouldn't you agree that it would be better to alternate weeks rather than you going 17 of 18 days without seeing Avery?
I do not agree that alternating summer weeks are best for Avery. No.
Okay. You mentioned changes that have occurred for Avery. Isn't it true that you chose to move to Montague?
Well, Judge, I think the court's opinion was pretty clear on why the defendant was forced to her parents' home. I don't know that we need to relitigate that.
I agree. It was already addressed.
But when we talk about changes, all right. Well, then isn't it true that you enrolled Avery in 2 years of preschool?
Yes.
And you chose to enroll Avery in writing lessons?
Yes.
Okay, and you moved her doctors?
I have not moved her doctor since living here, no.
Okay. And we can't blame COVID on anyone, correct? Anyone in this proceeding. Can we blame COVID on you or Bridget?
No, I guess I don't understand the question.
She
No.
wants to know if COVID is.
I understand it,
Oh,
and you're right. We can't blame it on anybody, except maybe the governor.
True.
The Chinese government, right?
I was being facetious, please.
I got that.
So wouldn't you agree that these changes are a result of your actions, not Bridget's?
no. I don't see enrolling her in preschool as a significant change.
Okay, well, you
as
testified
parenting
that this,
time.
you testified that she's gone through significant changes, and you mentioned all of these things aside from the doctors. So I'm just asking you, who created those changes?
Myself.
Okay. And don't you agree that it's important for Avery to be and work through these challenges with both of her parents?
What challenges are you speaking of?
The challenges that you mentioned about moving, about starting school, about COVID, about riding lessons.
Yes,
Okay. Then why isn't Bridget allowed to work through those challenges with her?
she is.
Okay. You testified that you talk with Avery during your workday. Is there a reason why Bridget isn't allowed to talk to Avery?
Bridget is allowed to talk to Avery.
Okay. Isn't it true that she asked to FaceTime on a day that she had to miss parenting time? And you stated it had to be at noon, knowing that Bridget's work schedule started at noon.
That's because that's when I'm available. It was a day that I was working.
So is there no one else that could have done a FaceTime visit for Avery and Bridget?
Correct.
No one could have.
Correct.
Okay. Isn't it true that the friend of the court handbook states that parenting time begins immediately after school or work? Is that correct?
The wording is and/or after work, after work and/or school.
Okay. So on Fridays, when she's to pick up after work, why is it that she can't pick up until 6 when she can be there at 5:45?
Well, Judge, I thought that we had covered on more than one occasion the willingness to switch times. I'm not sure why we're litigating this.
I'm not sure what your objection is, but I'm going to overrule it. Ask your question again.
Thank you, Your Honor. Why is it that Bridget has been, I'll reword it. Why has Bridget been denied picking up Avery at 5:45 and you insist that it has to be 6 o'clock?
That is what time our order is written for, 6 o'clock Friday to 6 o'clock Sunday. If I'm remembering things correctly, it was the midweek visit that she wanted to pick Avery up at 5:45 and 6 o'clock, not the weekend visit.
Okay, then why was that denied?
Because I'd like to have a set pickup time.
But you agree that the front of the court manual doesn't give you a set pickup time, right?
That we were basing that on Bridget's work schedule, and she was able to arrive to the location in a range between 5:45 and 6 o'clock. I wanted to have a set pickup time that was outside of the range in which she might be arriving. There could be a delay because of traffic or the weather, snow, anything like that. So if she was going to be arriving in a range 5:45 to 6 o'clock, I just wanted to have a set time. 6 seemed like a good set time because that's when we've used it for our weekend visits.
As of January of 2021, you were made aware that Bridget couldn't exercise alternating Wednesdays, correct?
Correct.
Okay, and that she was going to try and take comp time so that she could exercise some of those, correct?
Correct.
And she let you know that she might not be able to tell you until the day of, correct?
Correct. We have been on the alternating weeks that Bridget works and is expected to take comp time or asking to take comp time. Both my parents and I are notified up until 1 hour before the visit starts as to if she will be available for the visit or not. It makes scheduling difficult, and it makes it difficult for Avery to know whether Bridget's going to be there or not. However, that's what Bridget has asked of us, is that up until 1 hour before her midweek visit starts, she is able to ask for her comp time from her employer.
So you could just not schedule anything on Wednesdays, right?
Well, I work on Wednesdays, and so I have to schedule childcare, and Avery has school on Wednesdays, so we have to arrange transport to school as well.
And that's your parents, correct?
Both my parents and I.
Okay.
We
So it's not,
make the schedule.
so it really wouldn't inconvenience your parents to spend time with their grandchild on a Wednesday, would it?
No.
Okay. So you knew that Bridget might be able to exercise parenting time, but yet you scheduled a riding lesson during that time. Is that correct?
At the time that I scheduled the riding lesson on Wednesday, that was before Bridget had notified us that she would be taking comp time and that we would be on call up until an hour before. At the time that I scheduled the riding lessons, Bridget had just simply said, I will not be participating in my midweek visit every other week because of her work schedule.
And then when she told you that she was going to try and take comp time, she also said she could take Avery to the riding lesson. Is that true?
I'm not sure. I just don't remember well enough to be able to say yes or no.
One moment. Is there a reason why Bridget couldn't take Avery to a riding lesson?
The riding lessons are something that Avery and I do as a special activity between the two of us. So by removing that, it would be removing an activity that we do together. The secondary reason would be the drive time. The stable that she is riding at is, I'm estimating here, but 40 minutes from Bridget's home, and is in the middle of their midweek visit. So not only would Avery have to drive 1 hour to get to Bridget's house, they would drive approximately 30-40 minutes back to riding, 30-40 minutes back to Bridget's house, and another hour back to Whitehall. The riding lessons can easily be rescheduled to alleviate all that car time for Avery.
So are you saying that Bridget can't make the decision to not drive Avery to her house and then to the riding lesson and then to her house and then back to the exchange location?
That's well within her abilities to decide.
Okay, so she really could have done that. She could have picked Avery up, done something with Avery, brought her to the riding lesson, and then ended parenting time later. Is that correct?
It is an option.
Okay, and this is on a Wednesday, but you work on Wednesdays, and you said that you would need childcare on Wednesdays. So again, how did this riding lesson come up on a Wednesday that you work?
Again, because Bridget had told me that she was unavailable every other week for her midweek visit. When she became unavailable and the riding lessons became available at that time, I signed Avery up for riding lessons. I do believe that I told Bridget that if she was able to participate in her midweek visit, that I would just reschedule the riding lessons. Not take any time away from their visit together. They can spend the whole time doing activities of their choosing, not of choosing something that Avery and I are doing together. And I have rescheduled those lessons. So it is not an issue for Wednesdays.
You've cited travel time quite a bit for not wanting to modify parenting time. Isn't it true that changing to week on, week off in the summer would decrease the amount of travel time?
I have not figured the numbers on that.
Okay. And changing the school year midweek to an alternating Thursday night, wouldn't that mean Avery has a longer stretch of time in between her car rides?
By 1 day.
And this wouldn't interrupt her school schedule because she's off on Fridays, correct?
What wouldn't interrupt their school schedule? I don't understand your question.
An overnight on Thursdays would not interrupt her school schedule for kindergarten. Let me clarify that. Because she doesn't have school on Fridays, is that right?
Correct.
Okay.
The same as Monday or Tuesday, which were the previous proposal by Bridget. Now we have proposals.
That's not what I asked you. Do you agree that parenting time is the right of Avery?
Yes,
And that spending time with Bridget allows Avery to maintain that connection and that bond with Bridget?
yes,
Okay. Do you believe that the parenting time schedule that you're proposing allows Avery to be bonded with Bridget?
yes.
And if you had the amount of time with Avery that Bridget has, again, would you be okay with that?
And so I cannot judge what I might think about a hypothetical.
Okay. And isn't it true that really you just don't want Avery to have a relationship with Bridget?
That is completely false. Completely false.
I have no further questions, Your Honor.
Any redirect, Mr. Kronzik?
Your Honor, I'm good. I think the court has it.
Any further proofs, Mr. Kronzik?
No, Your Honor, thank you.
And Ms. Burks, do you wish to present any rebuttal testimony?
No, Your Honor, thank you.
I guess we're ready for arguments. Go ahead, Ms. Burks. Tell me specifically what it is you want me to order.
Yes, Your Honor. Give me a second to find that note, please. Okay. Thank you, Your Honor. I believe you've heard the testimony today. I know you've heard the testimony today and can agree that there's at least a change of circumstance to revisit parenting time. Bridget would like to modify the parenting time to every other Thursday overnight from immediately after school or 11:30 if there is no school to Friday at 11:30. Then alternating weekends on those weeks that she doesn't have a Thursday, still from Friday, but from 11:30 a.m. because Avery doesn't have school on Friday, to Sunday at 6 p.m. Then summer parenting time beginning after school releases on May 19 for alternating weeks. This would eliminate the 4 weeks of parenting time for Bridget, the 2 weeks for Sarah, just straight week on, week off. And then she would like 10 days of makeup parenting time for the midweek visits that were missed.
Mr. Kronzik?
Thank you, Judge. Your Honor, we are talking about a change in parenting time. The appellate courts have told us that Vodvarka still applies, albeit to a lesser standard. So I think we are in the realm of shade. Even at the lesser standard of shade, I don't think that we get to the threshold. Cited by the plaintiff are things like she's attained age 5. She has got 2 years of preschool under her belt. She's doing horseback riding lessons and developmental changes. Bridget's change is that she moved 1 hour away rather than more hours away. And that the changes regarding Sarah, and by the way, I don't think the changes to the parents are really relevant to a shade or Vodvarka inquiry. That notwithstanding, Sarah was, of course, living in Montague when this court made its last custody order. And they also cite that Sarah began working in March of 2020. So I don't think that we get to even the lower shade standard. That notwithstanding, the plaintiff proposes to add an additional 27 overnights to the current schedule, which would indeed change the established custodial environment. And then I think we now go back to Vodvarka, a change in custody. The plaintiff hasn't really indicated how this is a good thing for Avery. We've heard a lot about how it is good for her, just now how it's good for Avery. The plaintiff hasn't availed herself of all of her available parenting time. She indicates that she chose to forego 10 days of her parenting time. And truth be told, I don't think any of us would agree that these parties don't agree, don't get along with anything. And to the extent that giving her about another month of parenting time will help Avery when these two parents can't seem to agree on anything, just doesn't make any sense. Not to mention the fact that I don't know, none of us know when the Supreme Court may or may not come down with an order, which may be yet another change for Avery. And then once they change, if the Supreme Court decides that we're going to revisit this issue in the trial court will revisit it, which then again may be subject to appellate review and yet another change. So as Sarah indicated on more than one occasion, we're looking for stability, not change because the plaintiff's work schedule may change again in January, not change again because the Supreme Court may weigh in, not change for any reason. As we've said just so many times, I think we're beating a dead horse. The goalposts keep moving. So we're asking that the order remain where it is, that the court adopt those things that we have indicated that we're willing to adopt. That is, midweek be either on a Wednesday or a Tuesday, as the plaintiff's schedule permits. We are fine with changing the pickup time for the plaintiff to when Avery gets out of school, and other than and adjust the I'm sorry. Yeah, for the midweeks, and we are also willing to adjust the exchange location to make it convenient for the plaintiff when she is going up to a cottage up north. So we're as accommodating as we can be without doing too many changes for Avery.
Anything further, Ms. Burks?
Yes, Your Honor. I think for this court to wait until a Supreme Court decision comes down does a real disservice for Avery. She is being denied parenting time with Bridget at this point because Bridget's a police officer and her schedule changes. That shouldn't mean that she doesn't have parenting time because she has a schedule that changes. I'm certain she's not the only parent out there who has a schedule that might be modified once a year. The real question is how can Avery's relationship with Bridget be best facilitated and what makes sense for Avery? And the schedule that we have proposed makes sense. It doesn't, in the summertime, it's alternating weeks. That is very consistent, very regular. There's no communication between the parties because it is what it is. There is no, you chose this week, I chose that week. So that is very consistent. Yes, it adds overnights, but that doesn't change the established custodial environment with Sarah at this point. It just means that Avery gets a few more hours with Bridget, which she should be getting anyway. The shade standard, and I quite frankly believe that VAVARC has been met as well, in that both parties have said that there's been substantial change in their lives since entry of the last order. So with that, Your Honor, again, I just ask that you adopt the parenting time plan that Bridget has proposed.
All right, thank you, counsel. I want to go back over my notes. I want to look at the specific schedules here before I make adjustments. I want to be very careful that whatever adjustments I make don't create additional opportunities for arguments and disagreement. I want a schedule that's firm and solid that everybody can rely upon, since adjusting that schedule appears to be a challenge without placing blame on either party. Much as I'd like to see a greater level of cooperation here, I have to take into account the realities here that there isn't a whole lot of cooperation. So I will take the time to go back and review the schedules that have been proposed, the work schedules that exist, the school calendar, and come up with something that I believe makes the most sense for this child. Thank you, counsel.
Thank you.
Can I add one question?
Sure.
We are currently set before you on May 20th on the motion, the amended motion to modify custody. It sounds like, Your Honor, that you've already reviewed that and have already made a decision. So I just want to clarify that we can take that off the docket and that you'll include that in your order.
Yes, I will do that.
Thank you for asking.
Yes.